call. There is one other person in the call. Your camera is on. Your microphone is on. Your hand is lowered. Multiple people want to join this call. Use quote show everyone quote to admit it time.
ସେ BSW ପିଲାଙ୍କୁ ଆଡମିଟ୍ କରାନ୍ତୁ BSW କ୍ଲାସ୍ର କ୍ଲାସ୍ ଷ୍ଟାର୍ଟ ଆଡମିଟ୍ କରାନ୍ତୁ ନାଇଁ ସେ ଆଡମିଟ୍ କରିବାକୁ କହୁଛନ୍ତି
This call is being recorded, but classroom 2 hours evening fantasy.
ହଁ ମ୍ୟାଡ଼ାମ୍
Lisa Francis can now join this meeting. Aruna Mary and the 3 others can now join this meeting. Open the people list to see the visitors who joined from outside the meeting host organization. Hands in the feet left parent outside it and right parent join. And the arrow chime and one more join. Blessing 2 hours evening fantasy. This call is being recorded. Blessing Aruna Mary. Hands in the feet. Lisa France and the arrows. Blessing 2309 separator. BSW turn off microphone off. Turn off accent or react present now. Raise hand to the more options. Leave
So I'm hearing some voices. What are these voices?
Michael symbol left
Continue,
parent.
ma'am.
Yeah. All right. Yeah, I'll begin now. Yeah. Fine. Thanks.
You continue, ma'am.
All right. Okay. I'll do that. Yeah, I'll start with it now.
Your
Okay,
audio
ma'am.
setup is
Yeah.
causing echo. Go to
Thanks.
the more options menu for help. Your audio setup is causing.
So, good morning, friends. Still, we are very few of us. I think maybe we wait for 2-3 minutes more and then start with our session today. And today is our last class. So, as I promised, I am sharing my email ID with you all today. I told you in the last day I'll share my email ID. So, I'm sharing my email ID. When everybody joins, you all share with each other. Okay? So, today, like yesterday, we don't have many people, and yesterday everybody joined In another, by I think 3:20, 15:20, I have seen all of the students who are attending my session have joined. So I think I'll wait for another 2-3 minutes and then I'll begin. Yeah.
Control D, your microphone is on.
You go ahead, ma'am. Let them join. You go
Yeah,
ahead.
I'll do that. Yeah, I'll do that. There are just four of them, three of them. So only three students are there. So what do I do? I think I'll
No
wait
issue,
for.
no issue, ma'am. You continue. You will send the recording to them.
Yeah, all right. I'll do that. I'll begin with it.
Absent G left parent outside in right parent joined.
So good morning to all of you. Your good morning time. Yeah. So today, yeah, I'll share the PPT. So I think now you can see the PPT also. Okay. So today, yesterday we had, of our fourth block, that is major problems in marital life. So we covered the first unit yesterday, and that was psychosocial effects of divorce, separation, and migration. So that was touched yesterday. So today we are going to start with unit 2, and that is dowry demands and dowry debts. This is the second unit, and it has mainly three main aspects. First is Dowry Prohibition Act 1961. Then it focuses on legislative effort to curtail dowry, and then it will talk about dowry deaths. So these are the few topics that this unit is going to cover. So begin. So I'm beginning with the first part. So that is about Dowry Prohibition Act. So basically, dowry is a deep rooted evil in the society. In the older days, it was customary to give presents to the bridegroom and his family at the time of marriage. This used to be a provision for the couple to fall back upon in case of need. So, this system started at a time when girls were generally not educated or employed and has less opportunities to supplement family income. So there was also another reason for giving such customary gifts, as girls were not entitled to the share in the family property. The father, out of affection, out of love and other considerations, used to give some cash or kind to the daughter at the time of marriage. So this is basically a general concept of dowry in our Indian settings. This is what it is. So now, so So the object basically of this act is to prohibit the evil practice of giving and taking dowry. Since the problem is basically a social one, the government has tried to tackle it by conferring improved property rights upon women through Hindu Succession Act 1956. So now it explains what is dowry. Under this Dowry Prohibition Act 1961, dowry is explained under Section 2 of the Dowry Prohibition Act. This defines dowry to mean any property or valuable security given or agreed to be given either directly or indirectly by one party to the marriage, to the other party to the marriage, or by the parents of either party, or by any other person to either party to the marriage, or to any other person at or before or any time after the marriage in connection with the marriage of the parties. But this does not include doher or marine, case of Muslims. So it is not, it is something very different than what the Muslims practice. So here it explains penalty for giving or taking dowry. So that's, in general it has been said that if any person after the commencement of this act gives or takes or abets the giving or taking of dowry, he shall be punishable with imprisonment for a term which shall not be less than 5 years, and with fine not less than 15,000 rupees, or the amount of the value of such dowry. If the dowry value is much more than 15,000, 15,000 is the amount, and because this is Act of 1961, so that time 15,000, probably in today's, if I compare to our today's value, it may be in lakhs. Several lakhs will cost to this 15,000, that was, when this act was made. So all amount of the value of such dowry, whichever is more. But nowadays, of course, the dowry value is much more, because now the people are giving dowry in lakhs and lakhs of rupees and even crores of rupees. So that is being given. And then now next is dowry and central government staff. So in India sitting, it has been clearly, the people who are working in the central government jobs, they are barred from giving or accepting dowry. So that is something which is very important. If anybody is working in the government service, he or she is completely barred for giving or taking dowry. No government servant shall give or take or abet the giving or taking of dowry, or demand directly or indirectly from parents or guardians of a bride any dowry. So that's there. That is something which has been, here talked about. Uh, Still, we are very less here. Okay, anyway. So, next is penalty for demanding dowry. So, if any person demands directly or indirectly from the parents or other relatives or guardian of a bride, as the case may be, any dowry, he shall be punishable with imprisonment for a term which shall not be less than 6 months, but which may extend to 2 years, and with fine, which may extend to 10,000 rupees. So, this is basically which we have linked with the government, people who are in the government sector. Then ban on advertisement. So it has been also explained that nobody would advertise in the paper that he or she is willing to give any property or any kind of a dowry, for the marriage purpose. So there is a complete ban for that. So that's there. Then it says beneficiaries of the dowry, who all are considered, for the dowry, that they can get the benefit of the dowry. So section 6 states that dowry is given for the benefit of the wife or her heirs. Her heirs means anybody after her death, after the death, after the legal right the person or can inherit. So it is basically to the wife, or like if he she is not there, then whosoever has the legal right to inherit her property. So, where any dowry is received by any person other than the woman in connection with whose marriage it is given, that person shall transfer it to the woman. So that is important. So here there is a punishment for that. So punishment here, it says any person who fails to transfer any property as required, under these sections, therefore, or as required under this, he shall be punished with imprisonment for a term which shall again not less than 6 months, but may extend to 2 years. And the fine here is also, not less than 5,000 rupees. And in case of death, if the woman dies, so see, basically the woman is entitled to dowry property. So if she dies before receiving it, the heir of the woman shall be entitled to claim it from the person holding it for the time being. For example, if the dowry is with the in-laws, but her heir is her husband or her children, then the dowry is with the person who is the actual hire of her, who has the right. So if she has no children, then it may be transferred to her parents. If she has children, it will be transferred to such children, and pending such transfer, be held in trust for such children. If the children are small and they are not even in a position to hold the dowry items or things like that, so then it can be transferred to, then it can be kept in some kind of a trust, and then that will be transferred when they are in a position to hold it. Generally, we say that children, when the children are major, when they turn 18 and there are whatever the rights are, whatever things are for them, that can be actually given it to them. So then it also talks about right of court. So Act provides for for the appointment of dowry prohibition officers, lays down their jurisdiction and their duties and the powers of central government to make rules for the purpose of carrying out this act. So basically, right of court is the metropolitan magistrate. That is generally when we say in the judiciary. So judicial officers in India starts with the position of metropolitan magistrate. When they sit, so these dowry cases are generally held by the metropolitan magistrates, and what otherwise what we have studied, that is important. Next is legislative efforts to curtail dowry. So what are the legislative efforts to curtail dowry? Basically, it says the failure of the Dowry Prohibition Act to eradicate or even to curtail the evil prompted our legislatures to enact the criminal law. That is a criminal law was that Amendment Act in 1983. So, in order to deal effectively, not in with the cases of dowry death, but also with cases of cruelty to married women by their in-laws, amendments were made in the Indian Penal Code, the Code of Criminal Procedure, and Indian Evidence Act. So all these are different acts. So that has something or the other in relation to dowry. Some provisions which are related to dowry are also mentioned under that. So it has explained about Section 498 of Indian Penal Code Act, that cruelty to a woman by her husband or any relative of the husband is punishable with imprisonment for a term which may be extended to 3 years, and also with fine. So here they have also explained what does the cruelty mean. So, willful conduct of such nature by the husband or any relative of the husband that is likely to drive the woman to commit suicide or cause serious physical or mental moral injury to her. Other words, harassment of a woman by her husband or any relative of her husband with view to coercing her or any of her relative to meet any unlawful demand for property. So that's important. Then they have also talked about section 113A of the Evidence Act. As I have written here, the Indian Penal Code. So I shared of the uh, one section of the Indian Penal Code that deals with this, and uh, there is one section that is 1138 of the Evidence Act that also deals with this aspect. That says presumption as to abetment of suicide by a married woman. So in this it says if a woman commits suicide within a period of 7 years from the date of her marriage, or if it is shown that her husband or any relative of her husband had subjected her to cruelty. So this section of Indian Evidence Act deals with this subject. So it deals with this subject. So that's important. Then I have covered the first, that section 498A of IPC, Indian Penal Code, and section 113A of Evidence Act. Now, we now go proceed to dowry deaths. So, what do we understand by dowry deaths? you know. Yeah. So yeah. So, dowry deaths. In Indian society, woman has always been viewed as an ideal. You know, she is the ultimate force in the family and also in the protection of culture, heritage, and religion. But actually, in reality, this image has been shattered due to the unfortunate and disturbing phenomenon of incidents of bride burning that are on the rise at an alarming rate. So actually in India also, it is there that rice are being burned in many states, in many places. Maybe sometimes, it is there in both the places, in urban, whether it is an urban area or a rural area. At both places, it has been observed the brides are being burned. Yeah, and that is generally for the dowry demands kind of a thing. So, dowry killing is also a crime of its own kind. It becomes an immediate necessity for the husband and his family members to make the groom available in the marriage market. Thus, inconvenient brides have to be eliminated if they cannot feed the greed of their in laws. In a murder, there may be a motive or not, but in dowry deaths, it is inherent. The courts only have to examine as to who's translated it into action. It becomes a court's responsibility also to check who is the responsible for the death of a woman after the marriage. So there is one thing said by the Delhi High Court pointed out that once economic independence comes to women, the evil of dowry will die a natural death. So without education, the economic independence cannot be achieved. So this is something which has been observed by in India in Delhi High Court. This has been observed. In one of the cases, this sentence was there, so that was given an importance here in this literature also. So, nature of death. So, a death can either be natural, accidental, suicidal, or homicidal. It is for the court to conclude whether the death was homicidal, suicidal on the basis of the facts on record. So again, it is a responsibility of court to assess that. So framing of charges against accused are decided, you know, and that's basically it's a responsibility. The police is also responsible, and the court also has to see how and what is to be done and what are the important aspects under that. Then framing of charges against accused are being made. And if it is observed that this charge of an accused, in case of bride burning, it has become the normal practice to involve every member of the family or the in-laws of the girl, even if they are not in any way connected to the offense. However, the court is now expected to be swayed by the sentiments of the complainant family and try to rope in the innocent. So it is the duty of the court to shift the evidence justifying the involvement of the real culprit. So it is really very important. The court has a very important responsibility to ensure, yeah, that nothing of that, that if accused, and to see and ensure who is the actual culprit who has done that, and if there is any innocent, that person should not be punished for this. So it has explained section 304B of the IPC that also has certain things about it. I'm not going, nothing much here about it. So now I'm going to shift to evidence of dowry death. Since the crimes of dowry deaths are generally committed in the privacy of residential homes, and in secrecy. So independent and direct evidence is not easy to collect. This is the reason why the parliament introduced section 113A, presumption as to abetment of suicide by a married woman, what we have studied just a few minutes back, you know, and presumption of dowry death in the Evidence Act to strengthen the prosecution by permitting presumption to be raised if certain basic facts are established and the said death took place within the 7 years of the marriage. So here it is very important that even the court generally believes if there is a death of a woman in especially within the 7 years of marriage, so they have to ensure that the reason for that is not the husband or in-laws of the lady. So they examine every factor to ensure that who is as at fault for the death of the woman. So court is bound to take the fact of dowry death as proved until very strong and positive evidence is given and rebuttal by the accused. So that is again something important here. Now we move further. So with this, we have covered our second unit. Second unit we could cover very fast because it was only about dowry. Dowry. Excuse me. Excuse me. It was only about Dowry Prohibition Act, 1961. So we had in it. It is not really in very detail. So it was in very short explained. And sometimes you people observe, we see that there is a question also on Dowry Prohibition Act or something related to dowry. Once, I think I had seen a question about a dowry. Generally, there was a question about I have seen the question on divorce. We read about divorce yesterday. Divorce impact on life and growth of children. It's there because that is something really important. And then also the social consequences of divorce. That is there. So I think dowry deaths in India, legal remedies in case of dowry deaths in India, that question has come in December last year. December 22 exam, this question was there. That what are the legal remedies in case of dowry death in India? That means we have to explain, mainly this Dowry Prohibition Act and that the IPC section and Evidence Act section. So the two sections of these two different acts we have to explain, and mainly the Dowry Prohibition Act, what we have studied in brief because it is in 300 words. So whatever we have studied, we can easily explain in that. So then now we have the third unit. So the third unit is legal issues involved in the marriage. So here, we will study because we have mainly, in India, we believe in Hindu religion, Christianity, and Muslim religion. Six are part of Hindu religion, so we don't consider them separately. So because Hindu Marriage Act is applicable to six also, that anyway when we will discuss about the Hindu Marriage Act, we will talk about it. To begin with, we are going to discuss about the first thing is Christian Marriage Act law. So Christian marriage law. So basically, marriage is treated as a sacred bond by our society since ancient times. Strict rules were laid down about female morality, kinds of marriage ceremonies, monogamy as a rule, marital duties, roles and duties of sons, etc., by our Hindu society. You know, so after our independence, the India got independence in 1947. So various laws were enacted by Parliament of India. So we are going to study mainly about the few important uh, laws. So, first is Christian marriage law. So, the Christian marriage law, see, the provision of Christian personal law in regard to marriage are to be found in the Indian Christian Marriage Act 1872. It's long back, a very, very old act. So the act applies to all Christian marriages solemnized in India, wherever by the nationality or domicile of the parties. Section 4 of the Act provides that every marriage between persons, one or both of whom is or Christian or Christians, shall be solemnized in accordance with Section 5 of the Act. Otherwise the marriage shall be void. So here they have explained a few things. The first is persons authorized to solemnize marriage. So marriage under the Indian Christian Marriage Act of 1872, it can be solemnized. They have given the categories. First, by a person who has received episcopal ordination, then by a clergyman of the Church of Scotland, then by a licensed minister of religion, then by a marriage registrar appointed under the Act, or by a person's licensed under the Act to grant a certificate of marriage between Indian Christians. So, forms of marriage, it in a very brief, it has explained. Reading of several provision of Indian Christian Marriage Act, it shows that it can have forms of marriage are purely religious or purely secular, as well as marriages which are of a mixed character. So it has been explained here like this. So then marriage registrars. So state government appoints one or more Christians either by name or by office to be marriage registrar for any district under the Indian Christian Marriage Act. So it has been explained in very short. You know, the Christian marriage law has been explained in a kind of a very summary thing, and to I have noticed whatever papers I have seen of the last 2 years, because this course started from January 2022. So I have not seen any question based on the unit 3, what we are studying now. I have not noticed any question coming from this, but still we need to study. This is important that we need to understand the basic concepts of these marriages. So now it is a Muslim Marriage Act and Divorce Act. So in general, Muslim law is applied to every Muslim by the courts. A Muslim is one who believes that there is only one God and Muhammad is his prophet. This is the belief. Then marriage, concept and ceremonies. So in Muslim law, marriage or nikah, in Hindi or in Urdu we call it nikah, is a civil contract which has for its object the procreation of children. So, marriage, according to Mohammedan law, is not a sacrament by a civil contract. So, that is something which has been given, the small explanation given here. Then, ceremony. So, the essential ceremony of a Muslim marriage is proposed from one side and its acceptance by the other side. Izab wa Kabul, or declaration and acceptance. The proposal and acceptance must be made at one and the same meeting. So that's there. Then religious ceremonies. So no religious ceremonies are required for the legal validity of a Muslim marriage, though it is a usual practice to recite some verses from the Quran. That is very important. That some important, verses from the Quran.
Is mute. Hello? Your mic. Hello. You are not audible, ma. Hello, ma. I'm not hearing you. It shows that your mic is off. That's what it's showing me.
When did it happen?
You are you are audible now. At least 1 minute.
1 minute. Okay, 1 minute. Okay, I just repeat from the religious ceremony. I'm repeating so because it may be by mistake it has gone to a switch off. I don't know how it happened. So I'll just do it. 1 minute and this. Just give me a minute. It is not even presenting now. The this. So now it is visible and I am audible. It's okay, na? Now I hope it's
Yes,
fine.
ma,
Is
you are
it?
audible.
Yeah, thank you. Thank you. Somehow by mistake it has gone to mute. I didn't know. Okay, thanks. Thank you all. Yeah. So now I'll continue. Yeah. So it's I'm repeating the religious ceremonies. So no religious ceremonies are required for the legal validity of a Muslim marriage, though it is usual practice to recite some verses from the Quran. Some important verses from the Quran are important when any Muslim marriage is taking place. So that's important. It is not very important to have a priest, but somebody has to read some important parts of the Quran, for the marriage. Now, witness necessary for solemnizing. So, according to the Hanafi school of Muslim law, witnesses are required. They must be two males or one male and two females. A marriage not solemnized in the presence of witnesses is irregular, though not invalid. It is considered irregular but not invalid. It is still considered a valid marriage, but the importance is given to the witnesses. So that's there. Then rules as to polygamy and polyandry. So a Muslim male, we all know, matlab that is a general practice. A Muslim male can have four wives. This is the legal position. However, there are religious mandate that the husband should treat all his wife equitable, and if that is not possible, he should not have more than one wife. So this is also explained under the law. Then annulment of marriage. So there is no Muslim matrimonial cause act as such enforced in India. As such there is no annulment of marriage has been explained under this. Then judicial separation. So Muslim law also does not provide any special relief or any special obligations for this provision. So it is not there under the thing. Then divorce. So then it talks about divorce. So Muslim law, as and administered in India, it provides for extrajudicial divorce as the instant of the husband. I think I won't read these. There are four clauses given under the divorce who all can go for divorce under the Muslim law. So I'm not reading that. You can all read it. Then it talks about formula for pronouncing talaq, that is there. So talaq is generally described as in approved form, talaq is sunnah, or in unapproved form, talaq bidat. So these are the two ways which are in practice in Indian setting. The form of divorce described in Muslim law as khula and niabarat provide for divorce by mutual consent. If it is a mutual consent, that it may be known as khula or in niabarat. So that's there. Then custody of children on divorce. So it says that, under this act, that the getting such relief, the party interested in getting custody will have to move to the competent court separately by way of a petition under the Guardians and Wards Act. So there is a, in India there is, we have one Guardians and Ward Act. So it has been explained here that when it comes to after divorce, when it comes to the question of a custody of children, so the separate petition is to be filed in the court. Whosoever wants to take the custody will be examined by the court, and then the court will decide for the custody. You know, then temporary marriage. So there is a, you all may be aware of this custom, that there is a custom of Shia law permits a male Muslim to contract a muta marriage with Muslim female or with a female who is kitabia or a fire worshipper. A Shia woman may contract a muta marriage with a Muslim male only. The period of cohabitation should be fixed. It could be for a day, it could be for a month, it could be for a year or a term of years. And in some, dohar should be specified. So, muta marriage creates no rights of inheritance between the spouses. That is because it is considered as a temporary marriage. So, there is no question of any kind of inheritance among the spouses. So, children conceived during muta marriages are legitimate and can inherit from both parents. So, at least the children still have the rights to get the inheritance, from their parents. So, this is there about the Muslim Marriage Act. So now we will study, because now we are going to study about the Special Marriage Act 1954. I have seen, I was saying, because I have not seen any question of Hindu, Christian, Hindu, or the Muslim marriage, but I have seen a question in the past, in one of the in one of the question papers. I had seen a question of on a special marriage act, because this is something which is very special. This act can be used by anybody and everybody. All human beings living in India can use this act to get married. So, special marriage, known as civil marriage or a registrar marriage, is a marriage solemnized under the Special Marriage Act 1954. The main object of the act is to provide a form of marriage which is secular in character. Its ceremonies do not depend on the religion of the parties. You know, basically, if, for example, like if there is a marriage, if a girl is a Hindu and she wants to get married with a Muslim or a Christian male person, so it will not have any impact, because under this act it will be a secular kind of a marriage. It doesn't matter whether you are a Hindu or a Muslim or a Christian. So it can be availed by any person. So it basically, this marriage under this act is, talks about that it is a secular, then it is a statutory, then uniform throughout India, uniform for all person who avail themselves of the act, whatever, by their race, religion, or caste. So in this, there is something, a person marrying under the Special Marriage Act cannot have any other spouse while the marriage is subsisting. The marriage can be terminated only by a petition to the court filed on one of the specified grounds. Remarriage after death of the spouse is, of course, permissible. So, in this, it says the minimum age of marriage under the Special Marriage Act for bridegroom is 21 and for bride is 18 years. So breach of this requirement renders a special marriage null and void. You know, if a person who's below a boy who's below 21 and a girl who's below 18, if they get married, first of all, this marriage cannot happen under this act. But if somehow they are trying to get married, so this marriage will be considered null and void. Then we are going to talk about formalities. So special marriage act is solemnized after 21 days notice is given, so that objections, if any, to the proposed marriage may be considered by the marriage registrar. So that it means that is important. If a girl or boy of a different religion or a different caste wants to get married under this act, so they have to first register. And so there is a gap, only after 20 days of their application they can get married. So if any of the proposed marriage may be considered, so thereafter the marriage is solemnized in the presence of witnesses by the marriage registrar, requiring both the parties to sign the statutory declaration. So here the witnesses are also needed, and both the parties, have to sign a declaration. So that is important. Then registration. So registration of a special marriage is automatic at the time of its solemnization, since a certificate is issued on its solemnization. So the marriage, because this marriage takes place before the concerned marriage registrar, so he has to issue a certificate, so that is automatically there. So that proves the marriage has happened. Then annulment of marriage. So, a special marriage may be annulled by the court, on the grounds of impotency, insanity, pregnancy of wife at the time of marriage, coercion, or fraud. So, due to any reason, any given reasons, this marriage can be annulled. Then it says restitution of conjugal rights. So, restitution of conjugal rights means right to stay together. So, this is a term which is a legal term which is used for this. So, aggrieved party can file petition for a decree for restitution of conjugal rights. Such a decree call upon the other party to resume cohabitation. So basically, this restitution of conjugal rights, in a way, it says that if somebody still wants to stay in a marriage, so they move an application for this. But if the other person, that non-resumption of cohabitation after such a degree, becomes a ground for divorce in itself, you know, and that too if 1 year has elapsed since the decree. So this is the way. Basically, this provision can be used for the purpose of getting divorce. Then judicial separation. So judicial separation. 1 minute. I think I have to move. Yeah. So judicial separation. So judicial separation is a wife or husband who does not want immediate dissolution of the marriage but desire to live separately can seek judicial separation through court instead of seeking divorce. So that is there. Then grounds for divorce. So here there are different grounds for divorce have been explained. There are 12 in number. I think all those 12 points, I'm just saying a few of that. Adultery, treating with cruelty, desertion for at least 2 years, incurable insanity or mental disorder, you know, or the leprosy not contracted from the petitioner, venereal diseases in a communicable form, opposite party not being heard for several years, 7 years basically, and non-resumption of cohabitation after the degree of judicial separation for at least 1 year. So, likewise, some of the important reasoning is given for the uh, person who married under the Special Marriage Act, if they need or if there are reasons for them to take divorce, to get divorce. Then it says divorce by mutual consent. So this is again important. So divorce by mutual consent is available under the Special Marriage Act. So parties must present a joint petition to the competent court and must have lived apart for at least 1 year. You know, on such a petition, the court does not grant divorce immediately. The court has to wait for the specified period, and the parties must then again apply to the court for the grant of divorce, and in the matter reaffirm their joint determination to end the marriage. So this is important. The court considers when both the parties are not living together and they have lived separately for the year, and due to the grounds, different grounds, they consider the importance and they consider the divorce of a mutual consent. Appeals. So, against the decree passed by the competent court, if anybody has any grievances or anybody is not satisfied with the order passed by the court, then appeal can be filed before the High Court. So, in India, we have a first magistrate court, then we have a district court, then we have a High Court, and finally the Supreme Court. So, if somebody is not satisfied by the order passed by the district court for the marriage or for the divorce, for any reason of divorce, so they can file an appeal only in High Court, and it is always the state High Court, whichever the state they are living in. To they can go to the High Court of that stage to file any appeal if they are not satisfied by the order passed by the district court. Basically the judicial officer who has passed the final order for divorce. So children. So then first is maintenance of spouses. So court competent to grant matrimonial relief under the act is empowered to award maintenance, in favor of the wife and against the husband for such sums as the court thinks reasonable in the circumstances. So, such an order can be passed by the court whether the relief claimed is annulment of marriage, restitution of conjugal rights, judicial separation, or divorce. So, all such different categories, there is a possibility for the court to consider the maintenance part. Then it talks about children. So, under the Special Marriage Act, the court has jurisdiction to make suitable orders regarding the custody, education, and maintenance of children, and also orders as to who shall bear the expenses of maintenance. So, by this, we complete this Special Marriage Act. So, as I said, that there were questions, about this act, and this act is somehow important. So, what when I started about this Special Marriage Act, so first we are explaining what is the Special Marriage Act and what all formalities are there. Then annulment of marriage and the restitution of conjugal rights, judicial separation, grounds for divorce, then divorce by mutual consent, and appeal, maintenance of spouses and children. So these are the few important points what we have gone through. So you have to make efforts to remember some of the important points of this act, and your 300 words question you can answer accordingly in that. you know so that's how it has to go. Then we are moving to Hindu Marriage Act. So, what do we understand by Hindu Marriage Act? So, Hindu law of marriage is contained in the Hindu Marriage Act of 1955, which is an act of the Parliament of India. This act came into force on May 18th, 1955. The Hindu law does not allow polygamy or polyandry because that is allowed under the Muslim law, but it is not allowed under the Hindu Marriage Act. So, the Hindu law, yeah. So here it says here. Mm, huh. Hindu includes any person who may not be a Hindu but may be a Sikh, Jain, or and a Buddhist. You see here, this is important. When I was telling you, na, that under the that Sikhs, that we generally say that Hindu, Muslim, Sikh, Isai. In India we call it Hindu, Muslim, Sikh, and Christian. So Sikhs are used as a separate community, separate religion, but they are covered under the Hindu Marriage Act. So here it says, Hindus, but maybe a Sikh, Jain, and Buddhist. So they are covered under this act. It leaves out the Muslims, Christians, Parsis, and Jews. So Muslim, Christians, Parsis, and Jews are not covered under this Hindu Marriage Act 1955. So this is something important. You know, Here this is important, and then it says like. That marriage can be solemnized in accordance with customary rites and ceremonies of either party to the marriage. Monogamy is the law, and bigamy is punishable under the penal code. A Hindu and a non Hindu cannot marry under the Hindu Marriage Act, but they can enter into what is properly known as a civil marriage, that Special Marriage Act, under the provision of a Special Marriage Act. So here it says that the bridegroom should have completed 21 years and the bride is 18 years at the time of marriage. So it has been explained like that. Then it says Hindu marriage need not be registered except in those states where the state government has made it compulsory. If any state, it is like, India has many states, and if any specific state feels that this marriage under the Hindu Marriage Act is to be registered, there it needs to be registered. But every state does not have this kind of a Hindu marriage to be registered. So most of the in India, most of the Hindu marriages are not registered. Some what generally observed is the people who have to go out of India, or in certain jobs they are working, at certain places, specifically in certain places where they are working, they may be asked to provide a marriage certificate, but mostly it is not a requirement. So is there any problem, any issue? No, na? Yeah. Yes. So now,
Microphone is on.
No problem. Continue, ma'am.
okay, thank you.
Thank you, ma'am.
Yeah, now we are going to talk about restitution of conjugal rights, which we had studied earlier also. That I explained the meaning. That meaning is right to stay together, that is the actual meaning of a restitution of conjugal rights. So, the term restitution of conjugal rights in the normal sense means restoration of conjugal rights which were enjoyed by the parties previously, whether there was reasonable excuse to withdraw from the society of the other is to be proved by the party who withdraws. So this withdrawal involves a mental process besides physical separation, you know. So that's there, na? Because any such kind of a thing has a mental pressure, So it is that is there. Uh, so this withdrawal involves a mental process beside physical separation. So failure to render conjugal duties refusal to stay together or have marital intercourse with the other person would normally constitute the withdrawal from the society of the other spouses. So that has been explained. It says the aggrieved parties, can file petition for the decree for restitution of conjugal rights. Such a decree can such a decree calls upon the other party to resume cohabitation. So it is same like in the, yeah, in our special marriage act. It is the same provision is there under this act also. So non resumption of cohabitation after such a decree becomes a ground for divorce if 1 year has elapsed since the decree. I explained the same term in the Special Marriage Act. So it is more or less just the same here under the Hindu Marriage Act 1955. Then, judicial separation. So, wife or a husband who does not want immediate dissolution of the marriage but desires to give to the other party some time, you know, can seek judicial separation instead of divorce. So it is there, sometimes, there are, in married couples, they may feel that maybe we don't feel like comfortable to be with each other and let us stay separately for some time. So sometimes these separations can make them learn if who's at fault and what are the problems, and sometimes, living separately can help them to again come back and stay together. So this is the time which has been considered suitable, even for any court to decide on a divorce applications also, which we are going to study further now. So but for separation, so this is considered, as an important, especially a year period is considered important here. So uh, so the grounds of the judicial separation are the same as the grounds for divorce. This is basically a beginning. If there is a separation, so the separation period can again can be considered a ground for the to grant a divorce decree. So here now we are going to talk about what are the grounds for the divorce. So grounds for divorce again, I'm not going to repeat all. There are 14 points. In Special Marriage Act there were 12 points, and now under Hindu Marriage Act there are 14 points have been explained here. So I'm just saying few of that: adultery, treating with cruelty, desertion for at least 2 years, conversion to another religion, incurably insanity or mental disorder, incurable and virulent leprosy, when the disease is in a communicable form, not being heard of for 7 years, no resumption of cohabitation after the degree of judicial separation for at least 1 year, husband failing to pay the wife the maintenance order by the court, husband being guilty of rape or unnatural sex after marriage. So these are some of the important points, considered for grounds of divorce. Yeah, here they have for this, certain terms were used. So they had explained, adultery. Adultery means voluntary sexual intercourse between persons not married to each other. Then it has explained the term, out of these, the terms which I have used just now. So in this, they have explained the term cruelty. Treating with cruelty is a ground for divorce. Cruelty is not defined under the act. However, it means the conduct of a spouse which is of such a nature that the other spouse cannot be reasonably expected to live with him or her. So that is there. Then it says conversion. So if one spouse who's a Hindu embraces any other religion, the other spouse can petition for divorce on that ground. If somebody, if the spouses, any of the spouse, decide to change the religion, and the other spouse is not willing for that and not interested to, for her husband or wife to change the religion, so this could be a ground for the divorce. So the converted spouse cannot remarry unless divorce is granted to the other spouse. So that is there. Then mutual consent. See, under the mutual consent, a Hindu couple can, by mutual consent, obtain divorce through court. You know, the parties must present a joint petition to the competent courts. Divorce is not granted immediately. The court has to wait for the specific period, and then the parties must again apply to the court for grant of divorce. That is, they must reaffirm their determination to seek divorce. So this is important. Matlab, even here it has been explained that even if the couple is going under the Hindu Marriage Act, even if the couple mutually decide to take a divorce but court immediately does not grant, still give them some time. The time is not mentioned here. It could be 1 month, 2 months, 3 months, or maybe maximum 6 months period. So generally depends on the when the court meets the couple, and after meeting them, the court decide whether they would like to meet the couple to allow their application for mutual consent, maybe another 1 month to 3 months or 6 months time. And then if the court feels that they have decided and they are mutually still on the same grounds for the divorce, then the court grants the divorce. So that is there. Then then maintenance of spouses. So under the maintenance of spouses, while passing any decree for matrimonial relief, divorce, judicial separation, nullity of marriage, restitution of conjugal rights, anything, the court can make appropriate orders regarding the maintenance to be paid by one spouse to the other. So depending, the court has to take a view and a final decision. So in what circumstances, who has moved an application before the court, and what kind of a maintenance they have asked for, the couple, whosoever the whichever the spouse has asked for the maintenance, on the merits of the case, on the grounds of the application, and in totality observing the case, the court decides. So, Hindu Marriage Act empowers the court to direct that during the pendency of the proceedings, the wife or the husband shall pay to the other party as interim compensation such amount as the court considers reasonable in those circumstances. So amount can be varied if circumstances change. See, this again something which has been explained here, that it is for the court to see, in several other matters also, in several other acts also, there is a provision of interim compensation, your interim relief, or here we are talking about interim maintenance. So the court decide the amount for that, depending on seeing the income of the spouses and the need of the other spouses. After assessing the complete situation, the court decide what amount of maintenance and how much interim compensation can be granting while the case is in proceedings. The proceedings of the case is still on. Then custody of children. So custody of the children under this act, the court has jurisdiction to make suitable orders regarding the custody. So education and maintenance of children, and also orders as to who shall bear the expenses of maintenance. It is again court decides who will pay for the maintenance of the children. So, paramount consideration according to current judicial attitude is the welfare of the child. So, court will take into account to which parent the child is deeply attached, which parent will be able to bring up the child properly, what are the facilities available for looking after the child, and so on. These important aspects have to be seen by the court. If the child is old enough to express its preference, court will take into account that preference, though the court is not bound to follow it in every case. It is permissible to ask for the child to be produced in the court for the purpose. So here, under this Hindu Marriage Act, this is very important for the court to take a decision for this. The court Any child, generally in India we say the children who are above 5 years of age, for any matter under as you have yesterday also I had mentioned at one or two points the UN convention on the rights of the child. So in that there is one principle, that principle is principle of participation, or in other words the child to be heard, the views of the child to be taken into consideration. So similar way, when the court has to decide on the custody of the child, so court most of the time, I would say 99% I can say, that if the children are older enough to express their wish, the court generally asks them, and the court takes the view in the best interest of the child and considering the welfare of the child, where the children will be more safe and where they will be taken care of. So all those important aspects the courts look into before the court decides on this aspect of granting that who will get the custody of the children. So that part is very important to be considered. you know so the basically the court decide on the right of visitation. If by chance the court has given the custody of the children to the mother, so court allows the visitation rights to the father. It may be on a weekly basis or a monthly basis or a fortnightly basis, whatever the court decides. So accordingly, so the spouse who has the custody of the child, if the court has permitted the visitation right, so the spouse has to allow the second spouse to visit the children, because the court believes and the law believes that the children are born to the couple, so responsibility to raise the children is of the couple, husband and wife both. So even if due to whatever circumstances the custody is one of is custody of the child or children is one of the parent, but other spouse has the visitation rights, has to visit the child so that the children understand, the importance of both mother and father. So that is the thing that has been considered under this. Then proceedings. So for proceedings, the court is required by the Hindu Marriage Act to attempt reconciliation between the spouses who are parties to a matrimonial proceeding consistently with the circumstances of the case. Under this act, the court must sit behind closed doors if either of the party decides so or desires, or the court so desires, then accordingly it can order. So when the courts sit behind the closed doors, the press cannot publish the proceedings without prior permission from the court. So no proceedings are to be published in any media, anywhere in any kind of a newspaper or any kind of a media, until unless the court gives permission to the media to use that information. So basically, here the family courts are special courts to be established under the Family Court Acts, because these kind of cases are dealt by the family courts. So family courts are established under the Family Court Act of 1984, and they are intending to be meant by special experienced judges expected to follow a less formal approach than ordinary courts. You know, so basically, it is believed that family courts, though the courts have a formal environment and a formal atmosphere, but they can be slightly lenient. So they are to be considered to be less formal when they are dealing with these kind of a cases. So they can have certain proceedings, in camera proceedings, if the spouses, if the couple feels not comfortable to give their views before in an open court. So sometimes that can be considered. I'm not saying that is there for every case, but in certain cases it can be considered when the course is in when the case is in proceedings. Case proceedings are on. So with this, we complete our third unit. So we have in the third unit, we have talked about mainly four laws. First is the Christian Act, marriage law. Then we have studied about the Muslim marriage law. Then we have studied the Special Marriage Act, and then the Hindu Marriage Act. The four important laws we have studied in our third unit. So now we move to our fourth unit. So our fourth unit is going to talk about domestic violence, its causes and impact. It is a very small unit actually. But we will, I think, will not take very long to finish this. But it also has questions. You know, I have seen questions in the earlier in these 2 years question papers. The questions related to domestic violence about its causes and impact has also come, so that and it is not difficult also, it's very easy. So I would suggest to all of you to understand this, even if it is when you read it on your own you will be able to understand, and now when you hear me you will feel it is very simple, easy to remember, so it will be easier for you. So it covers four topics. For the first is theories on domestic violence, then it talks about categories and causes of domestic violence. Then it will talk about impact of domestic violence, and then steps to reduce domestic violence. So slowly we are going to study about these important aspects. So first, see, what do we understand by domestic violence? So basically, domestic violence is the willful intimidation, physical assault, sexual assault, and all other abusive behavior as part of a systematic pattern of power and control perpetrated by one intimate partner against another. It includes physical violence, sexual violence, psychological violence, and emotional abuse. So basically, domestic violence is a family problem affecting individuals in every community, regardless of age, economic status, sexual orientation, gender, race, religion, or nationality. So basically, domestic violence can be described as the power misused by one adult in a relation to control another. It is the establishment of control and fear in a relationship through violence and other forms of abuse. So, this is basically a very general meaning of domestic violence. Here it says domestic violence is a global issue reaching across national boundaries as well as socioeconomic, cultural, racial, and class distinctions. This problem basically is not only widely dispersed geographically, but its incidence is also extensive, making it a typical and accepted behavior. So that's there. So now, what are the theories of domestic violence? So, so there are five theories have been explained here. First is resource theory. So resource theory was basically brought by Arthur Gooday in 1971. That suggests that the more resources a husband brings to a relationship, the more power he has, but the less likely he will actually resort to violence. When, however, a man's superior power is threatened by a wife, access to educational or job related resources, he may resort to violence to re establish himself as a dominant figure. You know, then exchange theory, what is it? Exchange theory suggests that domestic violence will be particularly high in society where its benefits to perpetrators are high and particularly low in society where the cost of perpetrators are low. I hope you people understand the meaning of perpetrator. Na? The perpetrator is a kind of offender or who is indulged in immoral kind of act. So that is perpetrator. You know. So in most of the cases, male domestic violent cases are generally against women by the men. So that's there. So maybe in most of the cases, men are the perpetrators for that. So that's there. Then next theory is patriarchal theory. So under this, it submits that throughout history, males have dominated society and women were to be treated as men's possessions. You know, patriarchal norms protect man's ability to control their wives and justify their use of violence to do so. Next is modernization theory. So, modernization frequently leads to a valuing of universalistic over particularistic norms and achievement over ascription. Hence, we expect women and men to be freed from traditional gender norms as a country modernizes. So this is in a very simple way it has been explained here. Then economic dependency theory. So this has frequently been associated with decrease in women's access to educational, economic, and political resources. So they have explained this. So, what all are the theories which with we can relate to domestic violence? Now we will study categories and causes of domestic violence. So, physical violence is often identified by the community as a main form of domestic violence. So the different categories are physical abuse. So physical abuse means it includes directly assaulting a person like pushing, slapping, punching, kicking, choking, biting, shaking, inflicting burns, hair pulling, using a weapon. Maybe, for example, you can say belting, stoning, flogging with a stick, spearing, etc. Then next is sexual abuse. So sexual abuse is explained here. So trying to force someone to have sex or take part in sexual against their will, that is something very important. If anybody is trying to have sex with a person who's not interested, or using an object or body part to penetrate the vagina, mouth, or anus without the permission or consent, injuring sexual organs, intentionally hurting someone during sex, forcing someone to have unsafe sex without protection against pregnancy or sexually transmitted disease, or forcing someone to take their clothes off or remain naked against their will. So all these comes under the sexual abuse. These all are actually a very shabby kind of a thing, but this is something even I have learned about this kind of a sexual abuse in many cases, how the men, I would call them psychopaths, who indulge in this kind of a behavior with a woman, and this kind of a sexual abuse is being done. Then verbal and emotional abuse. So verbal abuse include the intent to humiliate, degrade, demean, threaten, coerce, or intimidate, and includes the use of derogatory language or continual put downs to highlight a particular part of a person's being or their societal role. So this is a kind of a verbal or a emotional abuse. Just a minute, I'll just take water. Yeah, spiritual or cultural abuse. So it is when power and control is used to deny a partner or family member their human, cultural, or spiritual rights and needs. Then you have social abuse. So, social abuse and isolation is commonly used by perpetrators to separate the victim from supportive family, friends, and community agency. So basically, this has particularly relevance for women in rural and remote areas where there is a limited access to cheap transportation or other kind of a support services or community services. So this kind of abuse happens there more often. Economic or financial abuse. So this involves the consequent And this involves the unequal control of finances in a relationship or a family and the deprivation of basic necessities. So this is basically we have here understand the important categories of domestic violence. So with categories the importance is the causes of domestic violence. So here in we will try to understand what are the causes of domestic violence. So, causes for domestic violence, So, there is no one single factor to account for violence perpetrated against women. Several complex and interconnected institutionalized social and cultural factors have kept women particularly vulnerable to the violence directed at them, all of them manifestations of historically unequal power relations between men and women. Basically, the link between violence and lack of economic sources and dependence is circular. On the other hand, the threat and fear of violence keeps women from seeking employment or, at best, compels them to accept low paid, home exploitative labor. On the other hand, without economic independence, women have no power to escape from a abusive relationship. Yeah. So domestic violence against women, basically this domestic violence, whenever we talk about domestic violence, it is not a recent phenomena, it is a very old phenomena, it says here in the book also, it talks about that women violence, domestic violence against women is an age old phenomena. Women were always considered weak, vulnerable, and in a position to be exploited. Violence has long been accepted as a something that happens to women. So that is a general feeling what we see and observe. So gender imbalance in domestic violence is partly related to differences in physical strength. Moreover, women are socialized into their gender roles in different societies throughout the world. In societies with a patriarchal power structure and with very rigid gender roles, women are often poorly equipped to protect themselves if their partners become violent. However, much of the disparity is related to how men dependence and fearfulness amount to be a cultural disarmament. Husband who batter wives typically feel that they are exercising a right, maintaining good order in the family and punishing their wives. You know, delinquency, especially the wives, failure to keep their proper place. That's how it is. So there is a report by Women's Task Force report 2000. It reveals work-related stresses, gambling and financial debt, the use of drug or alcohol, and access to firearms have also been identified as additional casual factors for domestic violence, though they may be linked to poor impulse control. That's there. Then it says, in the end, it says basically it is found that many of the victims of domestic violence has either refused to name the perpetrator of the assault or attributed to the injuries to other reasons. That is also there in India. We have this tendency that woman who is the domestic violence very prevalent, very there are many women who are being ill treated by their family of in-laws families or husbands, and they still keep on not going out to complain about it. They just simply move on with that, and they don't report it to anyone. So this has been explained here, and the last line of this chapter also talks about this particular causes of domestic violence, explains this. So now we are going to study impact of domestic violence, so what are the important impacts of domestic violence? So violence not only causes physical injuries, it also undermines the social, economic, psychological, spiritual, and emotional well-being of the victim, the perpetrator, and the society as a whole. Domestic violence is a major contributor to the ill health of women. It has serious consequences of women's mental and physical health, including their reproductive and sexual health. You know, so these include injuries, gynecological problems, temporary or permanent disabilities, depression, and suicide, amongst others. So that kind of scene things, all these kind of things, we see the impact. These kind of impacts we observe among women, even with all these kind of impacts also, but which they suffer, without making a noise of that, and they keep on suffering. And they still, many of that, as I just read, about the what all can lead to the injuries, what we have talked about, the gynecological problems, the temporary or permanent kind of a disability, it can lead, or depression and suicide in extreme circumstances it leads to. So this is really an area of concern for all of us. We really need to give importance that domestic violence, whatever we as a social workers can do, and make efforts to avoid, and not to create a situation that if there is any situation in existence anywhere, what all we can do as a human beings, and especially as a social worker, to control that. So domestic violence is the most common form of violence against women. It affects women across the lifespan, from sex selective abortion of female fetuses or forced suicide and abuse, and is evident to some degree in every society in the world. So the WHO, as per WHO, the World Health Organization, 2007. There is one report of WHO of 2007. So as per that report, it says that 29, between 29 to 62% of cases are of physical or sexual violence, or both. Physical, sexual violence, or both. So the figure varies from country to country, and it varies from 29% to 60. It is between 29% to 62%. It varies from the degree varies. And as per India, so India's National Family Health Survey, that was, again, this report is also from 2005 2006. So their national, the India's nationwide survey indicates this, the percentage as 37.2%, you know, of women experiences violence after marriage. So as per their report, as per the India National Family Health Survey report, so there is a percentage of 37.2, where it is seen that the married woman experiences violence. So this is something which is a real area of concern for Indians also, the people from India also. And it is worldwide, as I said, that the figure varies from 29 to 62% country wise. It may differ from country to country. So basically, so it says that the UN bodies have made some plans, some programs, some under some conventions. They are also working under the United Nations Development Fund for Women, that we call in a short form as UNIFEM, have worked to promote a culture of zero tolerance for violence against women. So they have also, done something for this. So that's important. So now we will study Here we are studying the impact on children. So, children who have witnessed domestic violence or have themselves been abused exhibit unhealthy behavior problems, including problems with their weight and their eating and sleeping habits. So naturally, if any child is a witness any domestic violence, he may have a sleeping or eating problems, and he may have even difficulties of different kinds that child can face. So they may have difficulty in schools also. Many times the school teachers report to the any parent who visits the school that the child is not able to adjust to the school environment. He or she is always tensed. So generally it is find it very hard to develop close and positive friendship. You know, it is again that these are the children at times not able to make friends, so they may try to run away or even display suicidal tendencies. This is an extreme. The children may show that kind of a something. So now what are the steps? So this is the last part of our class today. So, steps to decrease violence on women. So, several efforts are being made to address this issue. Two important measures are legal measures and awareness campaign targeting women, asking them to develop zero tolerance. So that is important. So, what are the important steps to decrease violence on women? First, attitude of men towards women. So most of the men are made to believe their masculinity is established only when they are able to achieve supremacy over the women in their lives. So it is expected that the men must treat the women in their lives with dignity, considering them as a separate individuals having their own aspirations and choices in life. So this is something which has been said for men, that they need to respect women and give them due consideration to do whatever they feel like doing in life. So attitude of women towards men. So in the process of socialization, women are made to accept the superiority of their male counterparts. She is always made to believe that the male members in her life will take the major decisions regarding her life. So women are actually responsible for their lives. Why do they need to believe the men will do anything and everything for them? So they need to believe in themselves that they are the one who can take care of their body and their needs. You know, so attitude of women towards women. So women are generally made to think that they are weak. They have to accept whatever their male counterpart decides. In many cases, mother and mother-in-laws will try to pass on such thinking to their daughter-in-law, to their daughters. However, it is the responsibility of all like minded women to alter such attitudes and make the woman to take the responsibility for her life. So generally it happens in India. We have a tendency that if I am a mother, I will teach my daughter that men are like that, men will do this, men will do that, you do your. But we have to, first of all, we really need to prepare our daughters or daughter-in-laws, you know to make them understand that first of all we really need to teach them to become self dependent, to give them education, to be trained to lead their life on their own. So that is important. Then social networking. So social working networking means women's participation in social network has been noted as a critical factor in lessening their vulnerability to violence and in their ability to resolve domestic violence. So, this network could be informal. This can happen through family and neighbors, or formally, it can happen in the community organizations, women self help groups, or affiliation to political parties. This can happen. Then, social networking can always help the woman to be more self sufficient, and to make a voice against any kind of a violence. So quality of family life. So quality of family life, most important measure is to enhance the quality of family life. you know so the most important thing that are required in the life are proper life skills, right attitude towards life. It is in this area that people are need of training. Hence, efforts in this direction must be increased. Such changes will lay a strong foundation for a healthy society where men and women treat each other with love, affection, respect, and dignity. So, this is what is required for a healthy society. So, this is with this, I think I have completed my all the four blocks. We have completed our course BSW 126 social work in family setting. So we are have completed this, and yeah. So now, so as we have completed with our course, and now few of you are here. So, as today is our last class, and as I promised, I have given my email ID to you all in the message thing. So, you all can see that. If there are any questions, if you have any questions, if you want me to say something, to tell you anything other than that, uh, so if there are, Anas, yeah, please.
Thank you, ma, for the presentation. I want more explanation on attitude of men toward women and attitude of women toward men. That's what I want to ask, ma. Thank you.
See, this is something which really depends on the society. So, as I was talking to you, and from the this book and this course, as you all know, is from the Indian setting and Indian side. So, we were talking about the how the men and women behave towards each other. So, basically, in every household, it is normal. So there are no domestic violence kind of a thing is there in mostly in most of the families, but in some of the families where the woman is not educated or is not working, and then she has to face a different kind of a violence at the hand of the husband, or if she is living with her in-laws. So many cases happen like that, where the domestic violence is to be faced by women due to it could be at times the factors could be the husband is not in a proper job, he's not even able to make money, to earn money, or another way, if he is not sexually satisfied by his wife due to whatever reason, or it could be due to the pressure of his parents, his mother or his father, that they are that his wife is not taking care of his family. If he is living in a joint kind of a family structure where the wife is not able to give proper time and proper care to the family of the husband. So sometimes these are the reasons. Sometimes, as we have studied about the dowry, so the we have studied about the dowry act today only. So even there also sometimes the reasons are like that. So dowry, even the dowry deaths we have talked about. So sometimes that is another reason for domestic violence. That, for example, to give you an example, maybe a couple got married where the wife's family has promised to give a vehicle, and that a car to a husband, to the husband, to the male spouse, when the marriage is being happening, and they promise that they will, when the marriage will take place, on the day of the marriage or just after the day of the marriage, they will give the car in a dowry to their daughter. But somehow, due to some financial reasons or due to whatever circumstances, they could not fulfill that wish of the boy's family or the boy's side. So that becomes a reason. So then they start a kind of a domestic violence kind of a thing, They start first with the violence, in a different way. They maybe, that could be in a form of physical violence, maybe in a form of emotional violence, sexual violence. It could be any form. you know the husband's either it could be either from the husband's side, or it could also be added by the husband's family. Could be his parents, could be his brothers, sisters. They all can make a group and try to put that kind of a pressure to the female, to somehow, as your parents promised for the vehicle, and I need a vehicle immediately. Either you stay with me, you can only stay with me if your parents can give me that vehicle, otherwise go back to your family or do whatever you can. Or sometimes they don't provide the 2 times meals for the day. So sometimes these kind of incidents happen, and that is something. These kind of things are in practice, I won't say all over the India, but in certain parts of India, maybe some rural places. And sometimes this kind of things are seen in a lower kind of a family background people, where there is not much of a education, where people are not educated, maybe doing a small course to run their family life. So this kind of a practice is generally seen in such kind of families. But I'm just sharing an example with you. Now, that example is actually from my family, but it is a very old example of, I would say, that example is of 1980s, where one of my cousin, she herself was highly qualified. She has done her MA and D.Ed. She was a teacher in a government school setup, and she got married to a doctor husband. Her husband was a doctor. But her husband was though he was a doctor, but he was a psychopath. So he used to ill treat her. When I was talking to you about the sexual abuse, so he was doing all kind of sexual abuses with that lady, with my sister. And I don't even remember what exactly his expectations were. He wanted more dowry, or he wanted, because she had given birth to a female child, and he probably wanted a male child in the family, or some reasons which were not really very meaningful reason. So he used to ill treat her like anything. So my cousin had come back to her parents house and stayed there for long, and he had come on several occasions to take her back. And finally she decided and had gone back to him, and somehow she delivered a male child. And after that, even today, that both husband and wife and their children are leading a happy married life and happy family life, I would say. They are okay, but initially I can never forget the trauma my cousin has faced in her initial married life of at least for first 5 to 7 years of marriage. So that kind of family, though that is an example what I have shared with you of an educated family, but generally this kind of a trend is more seen in the people who are not qualified enough to understand the different aspects, and to give respect and dignity to the human being. We as a student of social work learn these skills. We learn and we believe that we have to give importance to every individual. Every individual is a person of a unique personality. So that's there. So that is there. Is it okay, Anas?
Yes, Ma. Thank you for the presentation. I'm okay now.
Yeah, fine. Any other question, or anybody else has to ask anything? In all the 6 classes, I have told you about some of the important parts which you all must go through. I am repeating some of the things again. As I said, that in the assignment I have seen a question on a personality development that was there in my second class. Then today, there are questions from a domestic violence. This last unit what we have talked about, so there are questions on that. And under the different laws what we studied, I have seen the question on the Special Marriage Act. As I told you, I had seen the question on social change. We have studied in one of the units about that. Then about the importance of family, that the family life education, there are questions on that. And now I had seen a question on the family planning methods also, so like that. And some, and more or less there is always a question on causes of divorce and the reasons for divorce and impact of divorce on the life of children, you know, and the partner and the community. So these kind of some of the important questions are there. So basically, see, even all to see these are the things I have written down. It is there in my diary, but you all can see this on the IGNU website. So IGNU website has the question papers also, and IGNU website, as you have seen the assignment, you all need to make the assignments for that. So it will help you to do this. So this is how you can see the question papers. And as this subject is newly introduced, so the question paper for this particular subject are visible from June 22, 22, you know. Now we are in 23 October. So there are three papers, question papers visible on the IGNU website. First was in June 22, then December 22, and June 23. So there are three question papers which you all can see on the IGNU website. I have given you few of the important questions and few of the important aspects which you study, that will help you to, you know, do well in your exams. So that's, I think, all from my side. If anybody else has any question, you can ask. So if there are no questions, so all the best to you all, and it was really nice to, you know, have a class with you. I hope whatever I have explained, you will, I as I was told that you will get the audio recording of this, so you can listen to this again if you need. And I hope you all will do well in your exams and in your future life ahead. So all the best to you all. Yeah. So bye. And why can't we
Thank you,
see each
ma.
other's face today? Today is the last day and it's the bye. So let us see each other, you know, the last day in our last
Hello,
class,
ma.
isn't
You,
it?
you, you
Yeah.
haven't you haven't shared the email address for
No,
us.
I shared. Please check. Please check the message. I shared. I told.
Okay,
In
ma.
between
Okay.
also I told. Please check it before I close down. It is
Yeah, you have
visible.
shared for us, Ma. You have shared for us.
Yeah, I shared. I shared my email ID in the beginning of the class, and I told that you, as I promised that in my last class I will share my email ID. So if there is anything, you can mail. If I am in a position to answer, I will answer. You know, because depending on my work schedule, if I can answer you people, I will do that. Okay.
Thank you, ma.
Yeah. So no more questions, nothing. So goodbye to you all, huh? So nice to see you. Nah, so
Thank you,
we
Thank
ma.
could see
you.
the
Thank you
faces
very
of
much.
you all.
Thank,
So thank you. Okay,
Thank you, ma.
somebody, Emily has raised her
Thank
hands. Yes,
you.
Emily. Yeah.
No, I just wanted to say thank you, madam.
Oh, that's so nice of you. Thanks to all of you to listen to me for 6 classes for so many hours. You have to, you know, listen to me. So I hope I am clear enough. My voice is not, you know, clear enough for you all to listen and understand. Yeah.
Yes, ma.
So, all right. Okay then. Yeah. Okay. Bye bye. Bye.
Thank you very much.
And once
uh,
again, all the best to you all, to all my
Thank
friends.
you.
Yeah. Yeah. Bye.
thank you, Ma. Thank you.
Yeah. Bye bye. Bye. Bye.